Herb. I'm the executive director of Just Mediation in Pittsburgh. We're an organization that's been around for about 3 years, mediating landlord-tenant disputes to prevent evictions.
And good afternoon. I'm happy to be here. My name is Dianne Wainwright. I am the Deputy Court Administrator for the Civil Division of the Allegheny County Court of Common Pleas. That's our county court. We've been working with a number of stakeholders and partners in looking at housing issues, eviction prevention, and what the court can do. The court's piece of it, again, as Jim said, probably for at least 2.5, maybe 3 years now.
Great, thank you so much. So I've got a couple of questions. We'll have lots of time for questions from the audience at the end. The first question that I have for everyone on the panel is, for whom do you tend to see inequities in the system of housing laws, and maybe also how do you tend to see them?
Well, for the court, I will say we do everything we can at our court of Common Pleas to identify potential inequities in the process and in how we move cases, and we try to do everything we can to remedy that. So I want to kind of just go out there and say that from a process perspective and let folks know that our door is open to suggestions, and we're happy to work with people as to how we can make access to our courts better. With respect to inequities in the law, that's hard for a court representative to criticize our legislature. What I would say is there are areas that I earnestly believe we all need to be better educated about when it comes to preserving your rights as a tenant and preserving your rights if you find yourself facing eviction. And that's something I do think the courts can assist with education and doing programs like this and partnering with others to say, okay, what do we do to make sure that tenants know their rights, especially their rights when they are attending a magisterial district court hearing, and then when they are trying to file an appeal. So I guess that was, Chairman probably sounds like a darn lawyer, doesn't it? And I apologize for that. That's really the truth. That's where the court fits into this. But my hope is that Aaron's going to be more illuminated.
The setup, I like it. Yeah, I think thinking about inequities in landlord-tenant law and housing is important first to look at what some of the outcomes are, especially in our county too, because nationally we can look at these inequities, and sometimes I think it's a bit of a temptation individually for a lot of people to look at national trends and think that our area is different because we know the people that we're working with, we know the people that occupy some of these systems, and so we want to assume that we're somehow different, and we're not. In Allegheny County, I think it was in 2019 that the Pittsburgh Foundation had that big report come out. If you look at outcomes for how the court system works with landlords and tenants in landlord-tenant proceedings, which lead to evictions, if the landlord wins, tenants win 2% of their cases, I believe. Another 12% are settled between the landlord and tenant, and then the remaining 86% of cases are won by the plaintiff, who's the landlord and the property manager. If you're looking at outcomes like that, where one party wins outright 86% of the time and gets something of what they want, the remaining 98 total with their 86 plus 12, you're looking at a system that is unequal, at least. And to think of the inequities within that inequality, I think one of the things that mediation starts to address, but is not a complete tool for it and cannot claim to be a complete tool for it, is to say where are the points of access where we can level out playing field and in fact offer additional supports to people who do not have what they need to be able to simply walk to the systems where they need to be able to solve their problems. So in mediation, we're looking at these inequities, and we're looking at eviction disproportionately impacting Black households in Pittsburgh, immigrant households in Pittsburgh, and especially female-led heads of household in Pittsburgh. Mediation finds that Just Mediation in Pittsburgh are all of those categories disproportionately to the population of Pittsburgh. And mediation is trying to give access to people equally, and then also prop folks up a little bit additionally when it's not only fair to say, well, anybody can come to mediation, so doors open, walk right through, if you can't even find where that door is in the first place. One of some of the things we've done at JMP to try and address some of those inequities are, one, working with some of the partnering organizations within our county that help people get to resources. So that's meant working with a lot of the traditional sources like 211 or the Allegheny link, but it's also meant partnering with some of the resource navigation organizations that help people in need, often lower income folks, actually find the resources and not only say, call this number now, but actually how do you navigate within that place to be able to get a so in the mediation space, addressing rental assistance and working with folks like RentHelpPgh, which is a local organization, to be able to help mediation participants access rental assistance and actually get through those applications together so that when they come to mediation, it's not just two people talking about their problems and saying what they would like to do to solve those problems, but actually getting connected to resources to solve those problems after they've said that they would like to do that as well.
Aaron, can you briefly define mediation for the group?
Yes, of course, I'm sorry. Mediation is a process where two or more parties have a chance to sit down at the table together, virtually or in person, and have as constructive a conversation as possible to address the needs that they have in a situation of conflict and work with a third party who is the mediator to help clarify their issues, state their needs really clearly, and try and have those needs addressed by coming to an agreement with the other party. It can take a lot of different forms. There can be a lot of different timeframes. Dianne and I both oversee these different mediation programs that have really similar and then also really different criteria to them. But the goal is to get people together to make their own decisions and have as much self-determination over their own decisions as possible. I wonder if you would want to add anything to the definition.
Well, I think you did cover the definition perfectly. I would say people often think, I don't want to mediate. Are you kidding me? I'm right. Are you kidding me? I haven't had, adequate to eat, or I haven't had a washer and a dryer. I haven't had any of the things you're supposed to be in this lease. I'm not mediating. Forget it. I want to go to court. And while you may be right on all of those issues, sometimes rolling up your sleeves and sitting down and if you've got that neutral mediator, that neutral person who is able to hear what you're saying and really be a good listener, but then also hear what the other side is saying and help find that ground in the middle. You'd be surprised. Many times there's space in the middle, and a good mediation, in my humble opinion, I've heard it described in a lot of different ways, but a good mediation really sometimes is when both parties hold their nose and say, yeah, I can live with this. But it preserves a relationship and allows folks to stay or remain in a unit or property for a period of time that maybe they would otherwise be able to do. I wonder, do you have that cutout face of Kevin Quisenberry?
Yeah.
So we were supposed to have another person here today on our panel. His name was Kevin Quisenberry. He got very sick. And we said, absolutely do not come. We don't want you to be sick. But Kevin is a lawyer with the Community Justice Project. And so I wanted to try to hold up my Kevin Quisenberry face and answer the question about inequities a little bit. Not as a person from the court now, but I'm a lawyer with the Community Justice Project. This is all role playing here. Bottom line is, I know what Kevin would talk about in part in the inequities. And I think Aaron would echo this. And that is this concept. And it goes back to what I said a little bit about people knowing their rights. But this concept of a right to a lawyer, a right to counsel. We don't have a right to counsel for eviction prevention or eviction cases in Pennsylvania. I know there are jurisdictions in the country that are working on this, that are looking at it. But Aaron, do you have the statistics? I believe at the Magisterial District Court level, if I'm right, We've been involved in a program, not the court, but Community Justice Project and some other folks have been involved in a project called Lawyer for a Day. Is there anybody here? Chuck Terwilliger is outside. I think he's somewhat familiar with it, but Lawyer for a Day is where my understanding of how it works is at the Magisterial District Courts, there are lawyers sometimes there for the day to assist with eviction proceedings. And my understanding is just having that, where the person doesn't know the case in advance, or maybe doesn't have a whole lot of background with the tenant or know the case very well, just having that has improved situations for tenants dramatically. So instead of it being that higher percentage, 86% or more, always finding for a property owner or landlord, we see improved so that tenants have a better outcome of almost 50% of the time now. So it's leveling that playing field. So when we talk about a big question mark for inequities, you see that somebody who is a landlord who is represented, or even a landlord who's holding a piece of paper called a lease, is in a better position than a tenant. That's when we just see this, who is not represented. But give a tenant someone who is a lawyer who is skilled in landlord-tenant representation, and suddenly we level that playing field. So that's an inequity. It's not one of the things you were thinking about with that question. Yeah. So I just think on behalf of Kevin, we should make sure we talk about the right to counsel and the importance of getting more attorneys involved. And I don't know how we do this, truly I don't, but the concept of funding for pro bono or free lawyers to assist particularly at the magisterial district court level. So I've gone off topic, but now I'll take my Kevin hat off.
No, you're not off topic. I mean, that is basically my next question. If you could change one thing in our system of laws or administration that would provide more equitable access to housing, what would it be? Lawyer for a Day sounds like it's really making a huge change. Is there any other one thing that you would pull out that you would change?
Yeah, absolutely. I guess I'm looking at things that I can change within my scope of work too. So I'm looking at mediation to prevent evictions. One of the things that has been really limiting so far is the ways that mediation, right? We've spent 3 years to kind of pushing for mediation as an alternative to court. And it's very much a voluntary system right now, where a landlord and a tenant have to agree to mediate, and then they come to, and one of them comes to us, we check with both parties, and if they're willing to mediate, we set up that mediation, and they can come to an agreement that meets their needs. A totally voluntary system. To make this a mandatory part of the court process would be a really wonderful way to provide that access to everybody, instead of just the 2 people who are agreeing to participate on face value. So we've been working to with the county court system, and Judge Clark submitted a draft rule change to the Pennsylvania Supreme Court.
Minor court rules committee.
The minor court rules committee, which is the statewide body that governs the statewide judiciary. And we need a rule change to be able to allow for the landlord-tenant process to include mediation at the front, and to say, landlords, you're welcome to submit a landlord-tenant complaint to try to evict your tenant. And once you've done that, you need to try mediation before you go before a judge. And if mediation doesn't work, that happens, that really happens. So if it doesn't work, great, you can now go before a judge. But to give mediation a shot so that people have the chance to be able to work out their issues before they have to be at the mercy of a judge would be one way to be able to make sure that people retain as much power over their own lives as possible. We're doing this currently to try and do that post-filing, meaning after the landlord has already submitted that complaint against their tenant. That's something. What would be even better and much less harmful to both parties, especially the tenant, would be if we could do that pre-filing. So before a landlord said, I want want to try and evict you, I've submitted this to court, which goes on a tenant's record and can make it more difficult for them to get public housing or private housing in the future. To be able to do that pre-filing would be very important because it helps save costs and time and stress. It helps preserve housing for people in the future if you don't have even a complaint against you. And mediation is one way, pre-filing that you can avoid that situation. That's what I mentioned.
Yeah, again, I have my court administrator's hat on. As in the courts, I really don't talk about legislation and changing laws, but I would suggest that what Erin has described, I think is a great concept. And in fact, we have partnered to try to see if the rule change could help. I would just throw out again, let me go to my Kevin hat. I would throw out another brainstorming concept, and I like to think that hopefully today what we're doing is raising awareness about some things, but also maybe brainstorming. And just as a thought, what if there were funding to actually pay a property owner to agree to pay his or her filing fee if they don't file to go to mediation first. In other words, if you say, okay, I know you're in here, I'm the clerk at the MDJ's office. There's a new program with huge funding that's been funded by pick someone. And what we're gonna do, property owner, you've got a complaint, I know you want to file it, and I know you want to pay that money, but instead of paying me today, hold on to that money and sign up for mediation. And if that doesn't work, then come in and we will pay your filing fee. Do you think that would encourage landlords to consider mediation?
Anything that saves the buck, yeah.
I mean, that's something that I think people have looked at in other jurisdictions, sort of incentivizing a landlord to look at mediation as in more favorable terms.
We'll take a question right here.
I have a very quick question on the streets. I mean, a lot. I'm so glad you're going to do job. Say you don't have a problem with mediation. Where is the help in the law to help us as tenants as well as rental property owners that are going to most of the tenant definition for, say you got a rental manager and they just go in eviction, but you happen to know that their eviction does not have any merit, it's retaliation. Now, this is very important because mine too, and I'll give you a quick example. My two children are facing eviction that have moved quickly. I've been trying hard to keep them organized to be able to transition out of there. I've been trying to get them out of there. But because I addressed the issue and she knows she can get sued, she's trying to get me rid of me as a mom there and she's busy. Okay. Thank God he brought me in the time as there's the suit's going on. I saw another area looking for housing. They said, well, if you had an eviction, they can't qualify for the housing. Not only I want to address the issue to stop this eviction, we're trying to keep them out of there, but some of the traumatic accident, she would need a little bit more time. She seems like the type she moved, she's not compliant. We found the ERAP, we will supply any arrears. We want to get paid up so we can get the security deposit back. But because she's in the hope she's getting eviction, now she gets to dictate now. She's already wrong, and I can prove that. Because I'm going to be a lawyer too. I'm working on the paralegal, but I'm not sick. I help myself out. Okay, because I want to really be able to. So she's retaliating, wrongful eviction is no merit. She has no just cause why. Boom, you're getting out of it. So we've been trying. We're going to capitalize on it to help move quickly because I'm trying to get out of it. But where is protect us? Because I don't have the access to the information. The combination go with that, nor the preparation. For example, you got these inequities in the system. Where is the access to reports? How is it going to be made better for me? We're talking about that more for today. Okay, I like it. Now you got this here, this Allegheny County. There should be something across the board with a similar structure that will allow me to move the county. I need to be in Beaver County, we need to go to Westmoreland County. There's too many discrepancies as this county, and nothing to unify, nor to give us access to that. Mediation is good, but how do I get that to discuss? I want this, I got some demands.
Let me
I
see if
want
I
the
can.
eviction off, we want a eviction
Jeff.
off, you know, security deposit that, and we want you to complete this work. Not you just turn it down if the landlord, we qualify for this according to your federal power guidelines. So you should not the government should not give them all the power, just because you're not gonna stay there. I'm coming in, just because you're not gonna stay there, doesn't mean I can't get the help, get this accommodated and make a transition out of there. And help with storage and transportation, because we already found another source that was in your first month's deposit, but we don't need the eviction on it.
Let me see if I can summarize the question. The first part, it sounds like, where can I get legal assistance with the eviction process? And then there's another part, what if there is an eviction filed that appears to be retaliatory? And then the third part is, how do I navigate across, different systems of the courts? I got you. So I think the first part, where can I get legal assistance in the eviction process? The first thing that I would always say, and I'm going to turn it over to the other panelists, is I would probably flag neighborhood legal services. We have worked with them for many years. We often will say, if you have a question, if you're looking for some help, particularly in that space, I would say neighborhood legal services. But I just wanted to say something quickly about retaliatory evictions. Depending on what the retaliation is based on, you may have different remedies. For example, if it is based on raising a complaint of discrimination, that's the kind of complaint that my agency takes. So if you were to say, I feel like I'm being treated differently, or you were to file a reasonable accommodation request or something like that, and the next thing you know, you're getting evicted, that's the kind of complaint that my agency takes. Or you can contact the Fair Housing Partnership of Greater Pittsburgh. They can work with you on advocacy for the rights. I'm going to turn it over to the rest of the panel for some of the rest of the question though.
Well, first of all, it's an incredibly thoughtful question. And to tell you the truth, you've articulated how you're going to approach things in a way that you're well on your way. So I want to come back to that. But in terms of legal assistance, Mr. Terwilliger is here from Neighborhood Legal Services. They have a whole fantastic staff. But Mr. Terwilliger, raise your hand there. Okay, Neighborhood Legal Services. To become familiar with RentHelp Pittsburgh. Yeah, RentHelp Pittsburgh, and they have a great website, and you're welcome to call there to talk with them about the various resources that are available. They can steer you to Neighborhood Legal Services. When you're at the Magisterial District Court, there may be some assistance through the Allegheny County Bar Association's Pro Bono Partnership. There is a hotline for that. And the problem is the hotline is often inundated, and it may take a day or two for someone to get back to, as I understand. I know that that's taking a day or two to get back to folks in that hotline. But the bottom line is we need more legal resources to assist tenants. But what you've demonstrated is you've already done some reading. I mean, I will tell you, a lot of, and I don't, it's clear to me, you've already done some reading about what the requirements are for this this sounds like it's a federally funded program. And the landlord has certain requirements he or she is supposed to make, and it sounds like you're aware of those.
Denied the ERAP program, emergency rental assistance program. You got government laws and policies that are putting the resource to accommodate in the hands of a rentman, regardless of if my children want to say, well, I say to me, I don't live with like I guard in my household, so it's easy for one, we just might be in different places. When you're giving too much power for this rental manager, whether they like me or not, we qualify for this. we want this, and we still want that, we need some mediation. I'm willing to do that. If you're willing to talk, like you said, that's a very good point, because I didn't know we do that. We want a couple of things. We just want to get out of here too. And now we need the transportation help, like storage and a little high to make the transition. And shit, we're not getting here. This lady and the system we're at, they're like an in-house good. Okay, the sheriff, the judge, I can prove it, working in the system. It's a clip, this buddy, that buddy, and I'm not in, and you're taking it out on my children. So I got to secure a place because we're children are part of the suburbs. This is why when we get back up to the city, we got a lot more, but we can work with making progress in suburbs. Right now, we got to secure, get them to a safe place because we should have been out of here. The house is not safe. We were there, a lot of rust and things. So we don't got time. I could even get all 2 years, 3 years back of that money. I know I can't. Because I saw if we just show that we got proof of evidence, she thought that we were fair, yes, she wants some money, you know what I mean? Now, my son was like, not even 8 hours late, check dropped at 1 o'clock, he didn't want to wake her up, he goes at 8 or 9, boom, eviction letter, plus a fee. So it's wrong about that.
And again, I think Aaron can talk about how sometimes a mediator can take facts that you've just identified, and let me just talk a teeny bit about facts that you just identified. And let me talk about something that is important. Any documentation, photographs that actually have dates and times on them, letters from the health department, and Aaron, you can talk about this. I know when you come to court, a lot of times people get up and they say, well, let me show you my phone. I'm gonna show you my phone. Well, that's okay. But if you can come ready with something printed out that's easier to see and just throw that out there as we'll call that as evidence. If you've got evidence that supports your case, there is power. There is power in that evidence. There's power in the written word. There's power in that photograph. We all know that. And I would encourage folks to go armed, if you will, to that first magisterial district court hearing. Because sometimes people get there and they say, well, I didn't know I needed these documents today. But by the same token, and I'm going to turn it over to Aaron now, there is power in mediation. You raise your ability to negotiate and bargain when you have that kind of information. Okay, Aaron.
Yeah, and one of the things that I'm thinking about in your situation is the ability in mediation to ask for what you want. It doesn't mean you're going to get it, of course, but it sounds like moving out is important. We mostly mediate to keep people in their homes, but some people want to get out because the conditions are so poor and they hit their head against the wall of asking for things to be repaired and changed, and they haven't gotten a response to that. We see that absolutely all the time. And there's a better situation somewhere else, or you're just sitting where you are. And so mediating can also happen for those kinds of things too. Be like, how can we end this landlord-tenant relationship in a way that works best for both of us, so that we can just let this go. It's usually complicated, but it's actually possible to talk about, and not something that you have to just abandon and leave everything that you might have gotten out of that situation.
Yeah, we'll get to you after the next question. But one thing that I also was going to bring up was Pennsylvanians for modern courts. They have a lot of resources about navigating the system of housing law. So I would definitely check them out and see if you can get, I forget what that document is called. They have this big book of essentially landlord-tenant law that you can get to sort of help yourself through the system. But I did want to ask the panelists, thinking about, I think the two things that you brought up earlier. The first was essentially mandating mediation as part of the process, if not requiring it refiling. And then Dianne, you had mentioned, can you say again what you had said? The change that you, not necessarily the change that you want to see, but something that would be helpful.
Yeah,
The filing fee.
yeah. I mean, that's just sort of, that's just brainstorming and thinking outside the box and kind of throw it out to people. Do people think that could be an incentive?
Yeah, so incentives for landlords and tenants to work together, landlords to work with their tenants. What would we, yeah?
Here's a better suggestion for that thinking outside the box. In Pennsylvania, when you go to purchase a property, there is a sales agreement that almost 80% of people that purchase property in Pennsylvania use, which is a standard sales agreement that Pennsylvania's presidentially realtors put together. If that sales agreement, it clearly states in there that if you have a dispute with whatever process is going on within that sales agreement, or anything involving that the first option and the first thing you have to do is mediate first. So it seems to me that it would make sense in Pennsylvania that if we're going to dictate to people buying property that they have to use that one sales agreement, which outlines that as the very first line of defense, then maybe the court or the legislature should require that every landlord and every property in the state of Pennsylvania use the same rental lease agreement incorporated in that agreement, saying that mediation is the first line, and then if that doesn't solve it, then you have the opportunity.
Yeah, David, that's a really, great example. Model lease is something that we have talked a lot about. And, having one either for the city or the county or the state could really change the game for
Now
tenants.
remember that lease is already done. And it applies for the whole state. Okay, it's not for a certain year, it's not for every. It's already there.
A model lease. A model lease. The question is, what is it called, a model lease? I think, the question with model leases is what should be in a model lease? And there have been several types of lease agreements that could even include discriminatory terms. So not every, landlord thinks, maybe I need to have a part of this lease that is going to address discrimination. But if we're looking at a model lease for our city or for our state, that should be something that we consider, and in addition to perhaps having a mediation agreement. So that could definitely be a legal solution to that problem.
I think that's
Yeah.
a terrific idea. I mean, it's a great idea.
Yeah.
I don't know how much traction you could get, but again, you don't know until you start asking. We don't know until we start trying to push that.
Well, I will take that. I will take that as that's what I do. I go to, I'm an advocacy person for the state, so I will go to Harrisburg and we'll find out why that isn't in the agreement. And if that's the case, then I can see through the legislation now to divide the house to see if that's a possibility. I didn't know that wasn't the first option. I always thought that was the first option.
Because it isn't sales.
I mean, so now we have sort of three ideas on the table. We have ways to incentivize landlords to work with their tenants. We have requiring mediation as part of the process, either post-filing or pre-filing, and we have model leases that can address inequities with either mediation or ensuring that people can live free from discrimination by virtue of their lease. So I guess the question that I was going to present to panelists is, what are some of the things that are standing in the way work that we might need to do in order to get to some of these solutions?
No, in fact, I was hoping.
Was there a follow-up question?
Yeah,
So as far as the models, this one legislation to not allow those requirements to be waived.
Yeah, so not,
So she didn't even do this, boom, she kind of like.
yeah, can we maybe do like,
Put this little note, I got it right here, saying eviction. Right after I told her, I didn't get something about this is back in the. Next thing I'm talking.
this is a really good point, because not everyone might know
right,
not everyone might know what is in their lease when they sign it. So I think, the thing that had just been brought up is waiving your notice. Under the law, your landlord needs to give you notice prior to eviction, but it could be possible to waive that if it's in your lease. So I think the suggestion is to make that not a waivable right.
What is the notice part?
The notice to quit
Yeah.
is what the landlord gives to a tenant. A certain amount of days before they can then go to court and say, I am now filing to actually check the eviction. They first have to give a notice to the tenant before they then go to court.
No, it says you need to leave the premises within 30 days. And then you have to give that notice before you start the filing process. But the issue is that people signing the lease, not thinking there will ever be a problem, waive away that right.
So there can be something in the lease that explicitly says, I waive the right to this notice to quit. And then, and that is exactly the point, yeah.
Just so tired of being homeless, you might get abused, assaulted.
Yeah.
Bomb busting one, which is the law I saw in Florida, they were standing you up, you see you walking with bags, they're calling security, they're taking your stuff, and that really happens, okay? And now you need something. Now, I gotta agree to you, that's like, I call that a freedom enslavement entrapment for a special accommodation, but you don't have an option.
If we
You're
wanted
not
to,
allowed to do that to tell me, I gotta give up my entitlement to sue you, should you violate me, but you can't, but you don't give up yours to get me.
and if we wanted,
That's unjust, and when you're talking about unfair.
and if we wanted to see that change, what kind of things should we be doing?
Yeah, and that's like kind of a question that I want to further with another question too. So I'm not a lawyer, I'm not a landlord-tenant law expert by any means. And my understanding is that one of the big issues that you have been highlighting that all of us in this room know is that landlords have so much more power. An individual landlord generally has so much more power than an individual tenant. In the law, the landlord-tenant law is written with that power and that respect for property rights over the right for somebody to have a home over there. With that, people talk about wanting to open up the Landlord-Tenant Act and change some things in there to give more protections for tenants, which I think a lot of people would be very much in favor of. And from my understanding, there's a concern in that opening up the Landlord-Tenant Act to make some of these changes, if they need to happen there, and that's an if, because I don't know that. There's a concern that if that would be opened up, it would allow for landlords, landlord unions, property management associations with a lot of lobbying power at the state level would be able to then ask for their own changes and perhaps make a bad situation worse. I hear this batted around as a reason to not engage with reopening the Landlord-Tenant Act. I assume people know what they're talking about, and that's a real concern. And I'm wondering if other people with more expertise than I have are willing to speak to that, because
Once you open it up, you cannot control what you have.
Well, I feel we should open it up because we have, first of all, I'm the first one, we walk by faith and I just already see. This is what inspired me to go to law. There's a playing field. And when all the playing fields, we still here. You want your justice, but you're not administrative justice. You want your freedom, but you have to take mine. Now you're being hypocritical. Now you have an abuse of power. You're not allowed to do it because now you can't sit up there and say, because you're the landlord and I'm myself as a tenant. Now you can do what you want to do to me that violates the law, that's unconstitutional, my freedom of religion, to pursue, to have quality housing, my education, my freedom. Now they're going to mark me and scar me, but eviction, that's not going on my record. That's not going to hinder or create more barriers. Why are you not getting all that power? And your power is an abuse of power. You know, and why aren't you going here and trying to force me to waive this right? This is where the government should be coming and saying, no. Okay, I'm looking at them, but I'm actually excited because it's more opportunity for practice to learn, but it's not fun. But we're being out in the streets, you can't get a job, you're being harassed, you're being tied up in the law, and guess what? You can't get a job because of something that's coming. I think this way, they're staying and do whatever they want, and you're sitting there losing. Being held, and as Bob said, only back in the property,
right, and so at the state level, my understanding is this is where a lot of the rules are being made that have made such an unequal playing field. And the it sometimes feels like an excuse, but I assume that there's truth to that, and it's exactly right. If we open this up, we don't know what's gonna happen.
Right.
And not only do we not know, we have some guesses, and those guesses aren't looking so good, it's just that there's a lot of land. Or power. to meet their own
She got
interests.
the property, she got the money, she can go get her lawyer, because I'm trying to work my way out of low income. I'm gonna tell you, get enough to tell, I'm gonna work, I'm gonna go speak both, and I can't get none increase, because everything's down to being trapped, it's about money, and I do that money, and what I don't, so that means I lose. That ain't what God said.
You know, the issue needs to be framed in through the courts. If it's left up to amending the law, the reality is that right now in Harrisburg, the state, the legislature is divided. So if it comes out of the house, it's gonna die in Senate. So that's not, and that's the same thing in both our national politics. That's what I face when I'm in DC. However, if it's channeled in a way that the courts get to interpret and make the decision, that takes it away from the rather morass of the legislative process. And you might see a better and faster remedy in the courts, but again, it needs to be framed in a way, and obviously there's people here that are smarter than I am, that can frame it in a way that it would be addressed through the courts.
That's
solve this. I mean, we can't even do it. I mean, this requires sitting with, sitting, I mean, we
So I'd like to also throw out something else, because we could go down a discussion regarding legislation and that can take, I mean, we can talk about it, but as the gentleman just said, we're not going to solve it here. I want to throw out something different to think about. God bless you. And that is one of the situations that causes us to be in a state where one side really does feel like it has an enormous power is the lack of affordable housing units, because there's just not enough. So if I'm looking at a lease and I say, this tells me I'm gonna waive I'm not waiving notice. I'm not gonna sign this thing. I'm not signing it. And the property owner says to me, that's fine, go ahead. I got 17 other people ready to sign. So that's another situation that again, I have no answers here. And this is not anything that again, not anything that from the courts we have the power to change, but it is something. If you ask what's standing in the way, well, one of the big things, and it's been this way since the Pittsburgh Foundation reported in 2019 and before then even, there's a huge lack of affordable housing. And we really need to figure, that's another thing that needs to be, if you had plenty of housing and you could say, you know what, I'm not signing that lease, take that lease and have a nice day, landlord. I'm gonna go over and find a better landlord who's got a better lease. The problem is it just seems like, that's a very difficult position.
You're actually doing because they're doing leases and units as unconstitutional. So when I somebody like myself, I see an unconstitutional situation here, and violating my freedom, my housing, the quality of life, especially my religion. I want to take action. How can we deal with this? Is the question I want to ask. Yeah. When we got emergency crisis situation. Okay, I don't want my children in the street, my son, and a fatal accident. It's not appropriate. I'll go to the shuffle. I have to escape them secure, but I shouldn't have to do that. Where is the access to expedite these courts? You expedite when you want to 302. You expedite when you want to take somebody's children off them and didn't even do the doggone research. Because I got another lawsuit on becoming it's all natural. So why are you allowed to expedite that court to do something that you're not even fully capable of, and didn't even do the proper research? I'm not allowed to expedite the court because I'm not a lawyer, or because my mom didn't have experience, or because you guys money to get a lawyer. So that
So I think I'll say two things that came to mind. The first thing is, someone had mentioned, we won't solve it today in this forum. That's definitely true. But what I will say is that, the conversation that some of the people in this room, Aaron and Dianne and Megan and I have been having has gone on for about 3 years, I think. So, although we won't solve anything here in this room, the conversation is still going. And the question is, if we're not, and it's not that we don't have, legislators as part of that conversation. Sarah and Murado has been a part of that conversation. But if we're not going to go through legislative change, how can we make that change? Because, and this is the second thing I'm going to say, what we're talking about is tipping the scale back. There is sort of a hand on the scale of justice. And the reason for that has everything to do with why the Fair Housing Act exists and why we talk about affirmatively furthering fair housing. What we're talking about is historic inequity. Exactly what you had said, why am I not in the position of power? Because, my family didn't have 6 figures. Well, that's right. And it's a system that has been impacted and shaded and raised for the past 100+ years. So when we talk about making these changes that are not necessarily legislative, but doing everything that we can in our power to sort of tip the scale back, it's because the scale is already way over tipped. And by making some of these small changes, thinking about, if we're not going to, let's say, if we can't get a model lease that is, by the state, maybe we look at different landlord associations. Maybe we go through landlord associations. Maybe we go through, a building association. Maybe a single building, a single large landlord adopting something could make the change. So the whole goal is to tip the scale back. That's interesting idea that you brought up, expediting something in court. I'm not totally sure about the mechanics of it, but that's the whole point, is to think about when we look at this system, the scale is tipped, and the attempt is to kind of untip it, to take that hand off of the scale of justice, and to affirmatively further fair housing in that sense.
So I do want to mention, I'm talking a bit about the magisterial district courts. Those are the courts out in the neighborhoods. There are 46 in Allegheny County. Right? 46. If a party appeals, I'm sorry, go ahead.
It was mentioned in our discussion group, and I found it interesting that it is stated that the magistrate that is overseeing the eviction process doesn't have a fair amount of understanding about what is going on in the eviction process. Is that the case where the ruling for most of goes towards the landlord more so than the tenant, or is it like you stated before, not coming before properly prepared with our things already planned out?
So it's a great question, and it's one I don't know the answer to. But I can tell you, across, again, there are 46 different magisterial district court judges. They are no longer called magistrates. Okay, so just put that out there. I've been scolded umpteen times about it. Magisterial district court judges. It's a big long title, and they like it. They like it much better if you use their correct title. They don't like to be called magistrates. Just FYI, that's another tip of the day. So when you go, I mean, I think some know the law very well. Maybe some know different things better. But I can tell you, irrespective of how well that magisterial district court judge knows the law, you have more power when you are prepared and you bring your documents, when you've got your ducks in a row. That's why. Excuse me. My name is Dianne Wainwright. Dianne Wainwright. I'm the Deputy Court Administrator, Allegheny County Court of Common Pleas, Civil Division. So we're talking about these. Let's let's talk about 10 days. Can we all count to 10? We all can. I know that 10 comes and goes really fast. If you do not prevail before that magisterial district court judge, you have 10 days to file an appeal for possession. 30 days on money. If you're just worried about money, then you can wait a little bit. But if you want to stay in that unit, it is incredibly important that you get that appeal filed in 10 days. And who do you appeal to? The Court of Common Pleas. That's our court. And how can, this young lady is talking good bit about access. How do I get access? So I want to talk about Court of Common Pleas access. Administrative Judge Christine Ward developed the housing court through a task force that began in 2018, and then we implemented the housing court at the Court of Common Pleas in June of 2019. We believe that housing court collectively has improved access for litigants to the Court of Common Pleas. And why do I think that? Because I've been told by a lot of folks, but I know it because I see how hard we work at our help desk. So the Housing Court Help Desk is on the first floor of the city county building. If you have to file an appeal from a magisterial district court, you want to come to the first floor of the city county building, and there's a help desk team that can assist you. We also have a website. Type in Allegheny County Court of Common Pleas. You go to the website, Civil Division, Housing Court. We have tons of forms on there. That what I believe is what we've tried to do is give greater access to the courts, at least at the Court of Common Pleas level. And that's the part that I have a role in. So I just wanted to sort of respond to your inquiry about access, because I think at the Court of Common Pleas, we've greatly tried to improve it. I'm sure I know we're not perfect, but we've greatly tried to improve it. So.
Then the housing court is a subset of
Oh boy. Wow. Okay. So no, well, in my humble opinion, appellate courts are the Commonwealth Court, the Superior Court, the Supreme Court, right? So what we are is the Court of Common Pleas. We are the place you appeal from a magisterial district court, but right at the county. Your appellate courts are your Commonwealth Court, Superior Court, and Supreme Court.
Okay.
What I'm missing.
Well, I'm just thinking about your question about if it's somehow about different judges, different opinions, different rulings from those judges. If it's about people not being prepared enough when they come to court, having necessary documents and representation, like attorneys from folks like Neighborhood Legal Services. And it certainly seems like a combination, of course, which is the easy, boring answer. But I think just organization we need to like have the trust of the people who mediate, which is landlords and tenants, and know that they need to know that we can hear them and help them come to good decisions for themselves. There are advocacy groups within Allegheny County looking at how do we make sure that our court system gives as equal treatment to everybody as possible. There are so many really good judges on the bench within the magisterial district court system. And we know that with 46 of them, there's 46 humans. And so some advocacy groups are looking at what would it mean, who needs to be involved, because this is not something that comes from many elected officials' offices. It's very much a court system that has its own decision-making power about what's the best way to give both the most physical access to landlords and tenants across the county, which is one of the real benefits of the magisterial district court system in theory, is that if you've got somebody down the run over in Wilkinsburg, the judge who's just 2 blocks away. Talk about access, that's great. Of course, if you're up in Blackridge, it's a little harder to get to Judge Hughes' courtroom, so it's kind of tough. What's going to make the most sense for the courts to be able to hear these kind of issues? Is it 46? Is it some more regional courts along the bus line so that everybody can in theory get there? What makes sense? That's for other groups to talk about and prioritize as their action items. But I can say that we know that with programs like Lawyer of the Day, where people have representation in specific city courts right now, they went from having 2 to 14% positive outcomes for themselves as tenants to almost 50% positive outcomes for themselves. So representation really mattered in those court spaces. And a part of representation is somebody just helping you be like, what do I need to bring to court? Like, what are the documents that are going to help me make a good case for myself? And how can you help me do that? And so that.
Then do you think that continuing legal education for judges has a role in this conversation?
Wow, you're just trying to get me fired. I think continuing education all the time for all of us is important. Absolutely. The more we learn about how to effectuate fairness and the more that we keep abreast of changes in the law and keep up to date with case law, absolutely, we all benefit from that.
Well, let me rephrase the reason I phrased it that way is because not everyone might know that judges do continuing legal education.
Absolutely. So the judges do continuing education and have certain requirements to undergo continuing education annually. Absolutely. Yep.
That's one of the reasons, right? I'm not saying what's the person, they have to learn to continue the education for the judge. It's already more than likely, what I'm saying. But you don't even, and I'm not going into, we don't even have the connection for us, the tenants, to connect to the information. So we're getting all these cases, people being left unbalanced. I've been in this, I'm in this, I see how it works. Okay, I've never once been given the information to get representation, the right to know what my rights are, and then when they're violated, who do I call? And if they get the act in simple 2 days, 3 days, not dealing, some things can be, but then there's nothing I understand to do for an emergency situation to connect me to the authorized representation, as well as if I can help myself, because I can follow instructions if I got it, you know what it is. And I'm beginning to think that I just don't follow policies just because it is. I'm a different caliber now, you know, because you can have a policy that doesn't fit the situation and circumstances. We're not emergency situation. Myself, child, traumatized. You're not even connected to the resources. So I'm letting you know, as a team, and soon you can properly on the children. I want the rights access. Okay, I want the information. I can resolve the problem. I know what this is talking about. There's no help for us. It's not just your way. Your way is unfair. The playing field is all for you. How is that legal? You know about you. Now this is going into the okay, this is where it's still. But if you don't even, but if you read the chapter, chapter 7, it says extensive possessive. There's 2 keys, and there's 2 keys in this law. I know you don't want to do it. You cry out there, but when God is leading, the God says it's sinful possessive. So when I'm not, and I'm listening, and I see his purpose in about I'm not going to go into numbers, you probably understand, but I want the right to access the information. I want this situation dealt with emergency crisis situation. Now, as we get the accommodation, as we're dealing with the emergency situation, we don't sitting up under dangerous situations, no lights. Tell me that's not going to be shown done on either side. You can't even fit your food. You can't properly bathe with proper temperature and stuff. Okay, that is the situation. Emergency crisis versus situation is a time. Okay, it's not just you just say, "I'm sitting out somewhere." I understand what you're talking about is good because this was good to know because we got to come back again. We can really do this. I love to see you again. I'm so much.
Absolutely. And let me ask. Is there any other piece of information, any other question that somebody out there has for our panelists about sort of access or anything about what we are trying to do with some of the solutions that Aaron and Dianne have been working on? Yeah.
With the courts. If the person needs your value made by one day, it's not like that. How understanding is the court to let them get that through? Because I know that they give it to the people go to the courts, they hear from the magistrate, and sometimes they have to wait. They have to wait for the letter to come into the mail. telling them to go to the courts. So how understanding is it, or does it start the minute they walk out of court or the minute they receive the letter that 10-day countdown?
The minute you walk out, and so aggravating is heck, but that's why I talk with people who come to our court about counting to 10. If you come and I'm working the help desk, first thing I do is I look at your award. The first thing I do, I look at the date, then I look at the calendar, and I count. And I count every day after, so it's the day I still, it's a pain in everyone's neck, and I don't know that we have the power to fix it now. But, if it were rainbows and unicorn days, is what I like to talk about. If you had that, and those awards would be text messaged and emailed, maybe that would help us, right? Because I know, I didn't used to realize this, I really didn't. But I now realize the US mail is tricky. It doesn't always get there. If you have your hearing on a Friday, and then that award is put in the mail on Friday, but it doesn't really count, right? Because the mail was picked up at 2, and then they put it in the mailbox at 4:30. So now when is it going out? Okay, maybe it's going out on Saturday. Okay, so then maybe it comes on Monday, but you're at work. So you get home from work, 7 o'clock at night. You look in your mailbox, you see the stack of mail. You say, oh boy, you get up the next morning, now it's Tuesday. And you finally open it, but you have to go to work on Tuesday. So you can't come down and housing court about that, right? Trust me, I know how fast 10 days can go. And I know how difficult it is, but it is 10 days. And if we get you down there in 10 days, then everything is fantastic. If you miss it by 1 day, still come down to the housing court help desk. I mean, you got to come on down. We've got Chanel and Gerard there. They're fantastic. Quinn, who's maybe on our call somewhere, he's often there as well. Sometimes I'm there, but we will give you instructions. We cannot give you any legal advice, but we can talk to you about practice and what the policy is and what the rule is and what the timing is. We can tell you those things. We have a frequently asked question page. Look there for more information. So I can't tell you exactly what we have 3 housing court judges. They're all fantastic. Judge Conley runs the program. Okay, he's amazing. Judge McGinley, also amazing. She assists. And Judge Zeffie is also one of our housing court judges. They are fantastic. Okay, they are good listeners. I can't tell you what any of them will do on any given day, but if you come down and you have your motion to file a late appeal, because that's what it is, and you explain, here's the situation, Judge. I got it, but I couldn't get off work to get down until it was 1 day late. I can't tell you what they do, but that's a pretty strong argument. If you can, say again. Yeah, I don't know. Again, okay. So Mr. Terwilliger says it's probably going to be denied. Okay. Well, you've now thrown down the gauntlet where I'm going to have to take a look at the stats on that.
Is that something that I mean, 1 day, since we do, because it's not business days, it's just
10 days, that's right.
That's right. It was 10 business days, and it went out on a Friday, but then you can't count Saturday and Sunday.
No, you count 10 days.
No, that's what I said. It was 10 business days. Is that a practice that you could be changed? Because a lot of businesses, when you go by business days, practical 10 days. And that's something we can legislate for in place of it being a 10 days flat. Then they probably legislate for it to be businesses.
And
it's not giving the tenant a little bit more time and a little bit more leeway to get the money. Because some of them don't have that 195 or that 100 and whatever they're charging.
Then we're following.
And here's what I was.
How the tenant used to ask, not 15 days, ask for 15 days. We change it from 10 to 15. Okay. I mean,
And here's what I'll say, and I'll take the heat off the courts for a second, because this is something that we deal with at our agency as well. And I just want to say that in a lot of ways, there are times when we're dealing with a system of perhaps equality, but not equity. And when you look at, a timeline, our jurisdictional filing timeline is 1 year. And if somebody were to come to our office on day 367 and say, I only missed it by, 1 or 2 days, we cannot file it. And it is not necessarily equitable. It's equal, right? We're going to apply that same standard to every person who walks into our office. But does every person have the same needs to file? A person who's experienced discrimination has gone through a trauma, and perhaps that trauma has prevented them from filing within the year timeframe. So in a lot of ways, when we work with administrations and systems, we're working in systems of perhaps equality, but not equity. And that's what we were talking about earlier, where the scale is tipped. Could there be a rule change? There could possibly be a rule change, but still the scale is tipped. And I think, it will be a long time until we really address why it's so much more difficult for the tenant in these situations. But, it is important that we continue to have these conversations. Yeah.
I don't know that. So we're on with there are, we have still to offer some
I think that's an important point, because when we are looking at systems like these, the education is an important piece. I don't know that everyone would know that they could file an appeal. If I got a parking ticket and I thought I saw that the thing had passed, I would be like, oh, well, life is ended for me. I think, to know that, you could get legal advice, you could find out more, is an important resource, because that is part of how we start to rebuild the ability for people to have an equitable process, is to get the information out to as many people as possible about those filing deadlines and the ways that they can use the system.
the foundation of the USA is private property. And everything is based off that. So the bias toward the landlord is based on the fact that the landlord owns private property. And the bias against the tenant, so like, maybe that's that foundation of what you're living.
Yeah.
So, the lawyer of the day, so how does a person get in front of the lawyer of the day?
I'm not directly involved in the program, but Neighborhood Legal Services and RentHelpPgh, along with Ebony Law, are the 3 organizations that are part of that. Now we're closer to them, so I can speak to it a little bit. Right now, that's a program that only exists in the city and only in 4 of the 12 city magisterial district courts within the city, I believe. So it's Judge Cooper here in Homewood, Judge Wright in the north side, Judge Duncan in Brighton Heights area, Northview Heights area, and I'm forgetting, Petit in the Biddle district as well. So in that program, there's one that is going to be expanding into the county and throughout other districts in the city, but it needs a little more funding for that, but they're working on that right now. In that program, they have outreach to tenants who have been filed against. So they haven't just gotten that first notice from the landlord that said, I'm gonna file. They've actually had the filing in front of a judge and they're being called in for that first day of court. RentHelpPgh reaches out to those tenants and says, you have a filing against you, which is sometimes news. And they say, can we help you get some resources here? Are you behind on rent, or what is the issue here and how can we help? The goal is to be in touch with those tenants before their day in court so they can start that process. But if they do not get in touch before, they also show up to court that day of the week that the judge is hearing the landlord-tenant complaints to be able to explore rental assistance options and the programs available to them. At that same time, MLS or Editing Law has an attorney at the court for that same day too, and these two different organizations are working together to get the resources for folks to sign up for rental assistance and be able to stay on their own if they want to and avoid an eviction actually being defeated. Or at least have an attorney arguing their case before a judge. And so it's a program that's trying to match resource access with legal assistance in these specific courtrooms. And that's what's leading to those outcomes where there's almost 50%, 50% of cases end up being found for the defendant who's the tenant instead of the plaintiff who's the landlord. Does that answer your question?
That's very. I forget, but see, people on the lot, you think if you don't know the level of competency of that person.
Yeah,
I could sound all smart too. I'm going to do, I got some things I am smart, and there's some things I don't know, but it doesn't mean I can't learn. So you're not going to penalize me, because I don't know.
right. So you're asking how do you
You're
get
not
the
gonna tell
attorney?
me I'm required to know the block of education, we got injustice going on, and you tear down the system. The foundation is not, sorry, I don't really believe, I want you to make this please. No, I'm not saying the foundation is not the tenant, just because you that, I so, but you think you get the treatment down the way? Because I'm on your part, the foundation is what it's on.
I-
God is justice, being in the law, because God is the law, okay? Now,
I think.
I want to know how to, this lawyer of the day was studying law. Does it go county to county, or is that only in the?
Yeah, good question.
It's
It's
doing a lot, but you're not, when I'm not yelling at you there. There's a lot, but the access to a board of commissioner, I want to take action. I want to get it, and I can do what I can, and what I can't do, want to help. They're not going to keep stomping in the system, talking about, yo, I gotta ask you for my right, no. Your failure to inform me, I'm entitled to. I didn't go to school for law, yeah.
I think it's important
So
to,
don't expect me to do the job of a lawyer, but you keep using that as a weapon, because I don't know, and I'm being let in the trap, because that's not.
right.
And that's why we see some of these people fall into the system, they don't know how to help themselves.
I think it's important just to differentiate between the lawyer of the day program and a court appointed attorney.
Right.
Because I think in civil matters, there's not court appointed attorneys, but the lawyer of the day is a resource. I don't know, Aaron.
Right, and so, and in Allegheny County, so lawyer of the day, I was kind of highlighting how limited it is right now. It is not everywhere, and that is a funding issue that is a real detriment, but it is trying to prove the point that when people are represented, like you're mentioning, like when people who need representation are represented, good things happen for them. And so in these 4 courts out of 46 in the whole county, which is a pretty low percentage.
You should prove to me I can do this job. I don't have to do that. I don't have to do that, you know.
Make sure I understand. Yeah,
I think we have one other question, and then I think we'll wrap up. Do you have a question?
Yeah, I'm just curious what, between court and mediation, we just had a case recently of a Section 8 tenant who received a notice of non-renewal. And then they sent a copy of her payment list. And then they were saying that her rent portion, which was $5 at one point and then $0 the majority of her was, coming into. And when we drilled into it, we realized that what had happened was that they have a payment for it. And they would have this dispute with the housing authority about the Section 8 payment. And the portal didn't allow for partial payment. So she couldn't pay her $5 when the $800 in the housing authority was owed, because the portal was only accept $805 payment to cover the balance. So on paper, they were making a case that was set up for her to fail because of the dispute they were having in the housing authority. So, but I've seen this overall about landlords refusing to accept even a partial payment to mitigate their damages. And then presenting in court a discussion on you haven't paid anything while the tenant's trying to get out, I've been trying to pay, but you haven't accepted it. Can you talk about like the legalities of that, and then if you're seeing that in mediation, Aaron, with people willing to accept partial payments or payments?
I can only speak to the second half of that, and then you turn it over.
Yeah, and I will tell you, I would defer to Mr. Terwilliger on the first half of your question
Yeah.
too, because I'm not comfortable giving you the legal advice on that either.
There's actually.
In mediations, we've talked a lot about how stuck the law feels in this inequity between landlord and tenant. One of the benefits of mediation has been that we work with large property management companies and the housing authorities of the city of Pittsburgh and Allegheny County to be able to get mediation in there for a lot of their cases, so that they're not evicting many people right now at all. When we have those relationships, we're able to work with the idea of payment plans, of partial repayments, and of being able to connect to rental assistance to stave off eviction. And that has been a huge silver lining that is incomplete, but is a silver lining. We are also aware, as the mediators, we are not there to say if this is a good or bad agreement. We are there to make sure that both parties understand it completely and are making their best decisions for themselves, and they feel like they're making their best decisions for themselves, as you say. So we have seen a lot of payment plans for folks with limited financial resources, where they're suddenly having to pay the maximum of 40% of their income in a repayment plan. Which is by definition unaffordable if you have a limited income and the max you can pay in rent to the housing authority is 30% of your income. That is not a sustainable solution. It is better than an eviction in the exact moment that that payment plan is being made. But if it is by definition unaffordable, it means that in a month or two, unless some miracle happens, which is not something we should be legislating for, we're looking at them being before a judge again. So we see that happening. We see property managers being willing to do that in mediation, and it is not a long-term sustainable solution.
The one thing that I would say to respond, and I will tell you, when they come to mediation on at the Court of Common Pleas, it's the day of the arbitration for that. We offer it, but many agreements include language where that the landlord has agreed to accept payment from a third-party entity. And we put that in the agreement because during mediation, it has come out that perhaps the landlord has not always wanted or been willing or accepted payment from a third party. So we put that in the agreement. And what is that agreement? It's a consent order that is enforceable, not appealable, but it's enforceable. So if the landlord then refuses, you just come back down to the Common Pleas and appear before one of our housing court judges and explain that the landlord is refusing to accept the money from the Baptist church or from ERAP or from wherever it's coming. So I will tell you, our mediation program works a little different than Aaron's, but it's the same concept that we don't force anyone into mediation, but we offer it. I'm sorry, did I see it? Yeah, yes, sir.
I am a landlord who uses part of the thing. I can take it. Whatever you give me, I will take it. I will take it. However, the tenant, if you know something is going to go into the don't hesitate to talk to the landlord. No, because now you're acting like if you have, it will go away. It's not going to go away. And there's each month, each day, the amount is more and more and more. So you go from 30% of what you're coming to 40%, and you can't pay it. Then the landlord's going to use that against you. But to me, is that I would kind of be like up front as possible. And and that's not to do something, but don't try to hide and think it's going to go away, but it's not going to go away.
So I'm sorry.
Financing already. I have had financing at 5,000, 3,000, 4,000, and I try to tell them what we get is like a drop in the bucket, and your landlord can still be with you. Have you talked to your landlord? Have you tried to set up a payment plan? Once you set up a payment plan, you have to be practical Don't set up a payment plan where you know you telling your landlord you can pay $300 more on your rent, when in practicality, you cannot. Right, so set up a payment plan where as if you look at what you making, do a budget, and then say, I'll pay my current rent plus maybe 150 until for so many months. And people don't realize if they do the calculation, they can see how long it would take them. As long as the landlord is willing not to keep acting on, and this is what a lot of landlords do, tack on late fees, late fees, late fees. People cannot get out of debt that they owe you if you keep tacking on late fees. So when they call us, I suggest they sit down and talk to the landlord, explain the situation. But so many times, sometimes people come who don't have a job, but they don't feel like that's the main important thing, getting an employment. But the other side of it is they're not being practical, they're not talking to their landlord. They're not trying to set up things to keep them from being put out. And I wish there was a way that you could, if the courts, like you said, your courts, they can file, the courts can help them follow that appeal, to give them that time to make an arrangement or set up something in place with them in their landlord. And they have to be back, the tenant and the landlord, both have to be.
So we cannot technically, we can't represent somebody, and we can't help you file your appeal technically. I guess it depends on the semantics of that, and lawyers are great for talking about phrases, but I mean, the bottom line is you come to our help desk, we're going to give you documents and information and explain how to file the appeal. We're not going to write it out for you. We're not going to fill in the blanks. You will have to write it out. But I do want to respond to something because I was blown away by the statement that you're probably going to be denied. One day late, you're probably going to be denied. Because I will tell you that was contrary to what I thought. So I shot a quick note to our statistician who's also listening in. And I will tell you in 2022, 218 motions for late appeal were granted. Now, I will tell you that's only about a third of the total that were filed. But as Mr. Williver said, even when the ones are denied, there are times the court will put in the order some avenues that delay an eviction. So you ask for the late appeal, and the court may deny the late appeal, but indicate that we're going to give you a little more time to get out. So I do want to be clear that Housing Court Help Desk is there for you if you're a day late, 2 days late, or, obviously, this isn't rocket science. It's not even law. It's common sense. The longer you wait to tootle down to the help desk and try to get a motion for late appeal filed, the harder it is, right? The more difficult it is. So, but I did want to make sure I at least chimed in for 2022. There were 218 motions for late appeal.
For example, not straight through up the office, but not on page. So when I have to got a regular couple of videos monitor how that works. Or if you have like you have to put not I was doing
Right.
I was in the hospital and I was like, that's what we do.
And that's a great point. And again, the help desk can't tell you what to put in your motion for late appeal, but what they would do is give you the documents with some instructions and say, tell the court why you were late. And so that's how that would go. But again, that's at the court if I don't think you're taking that. And I think we're up against time, so. And like that,
We're up against time. I want to say thank you to Aaron and Diane. I feel like we've gotten a ton of information. And I really appreciate you coming down and talking to us about the legal system and the things that we're doing and the things that people can do to sort of protect their rights. So I want to give a big round of applause to Aaron and Diane. We are at the last part of today, but we will have more content tomorrow. I just want to say thank you for coming out, for everyone who's here. Thank you to our staff who've been running around and getting everything set up. And I want to wish everyone a good night and a happy continued Fair Housing Month. And hopefully we'll see you tomorrow.
I just think I really have to say something. I want to file a complaint on the judicial system. Who do I contact over the system for the Pennsylvania? It's directly to your contact. It might be like information. I'm not complaining in county. I'm not minister. I don't want to. I